Criminal ACT. Act Number 0. Act Number 293, September 18, 1953. Act Number 2745, March 25, 1975. Act Number 4040, December 31, 1988. Act Number 5057, December 29, 1995. Act Number 5454, December 13, 1997. Act Number 6543, December 29, 2001. Act Number 7077, January 20, 2004. Act Number 7427, March 31, 2005. Act Number 7623, July 29, 2005. Act Number 10259, April 15, 2010. Act Number 11574, December 18, 2012. Act Number 11731, April 5, 2013. Part 1 General Provisions. Chapter I Limit of Applicability of Criminal Code. Article 1. Criminality and Punishability of Act. 1. The criminality and punishability of an act shall be determined by the law in effect at the time of the commission of that act. 2. When a law is changed after the commission of a crime, such act thereby no longer constitutes a crime under the new law, or the punishment therefore under the new law becomes less severe than under the previous law, the new law shall apply. 3. When a law is changed after the sentence for a crime committed under the previous law has become final and such act thereby no longer constitutes a crime, the execution of the punishment shall be remitted. Article 2. Domestic Crimes. This act shall apply to both Korean nationals and aliens who commit crimes in the territory of the Republic of Korea. Article 3. Crimes by Koreans outside Korea. This act shall apply to all Korean nationals who commit crimes outside the territory of the Republic of Korea. Article 4. Crimes by aliens on board Korean vessel, etc. outside Korea. This act shall apply to aliens who commit crimes on board a Korean vessel or Korean aircraft outside the territory of the Republic of Korea. Article 5. Crimes by aliens outside Korea. This act shall apply to aliens who commit any of the following crimes outside the territory of the Republic of Korea. 1. Crimes concerning insurrection. 2. Crimes concerning foreign aggression. 3. Crimes concerning the national flag. 4. Crimes concerning currency. 5. Crimes concerning securities, postage and revenue stamps. 6. Crimes specified in Articles 225 through 230 among crimes concerning documents, and 7. Crimes specified in Article 238 among crimes concerning seals. Article 6. Foreign crimes against Republic of Korea and Korean national outside Korea. This act shall apply to aliens who commit crimes, other than those specified in the preceding article, against the Republic of Korea or her nationals outside the territory of the Republic of Korea, provided that this shall not apply in case where such acts under act in effect at the time of the act do not constitute a crime, or the prosecution thereof or the execution of the punishment therefore is remitted. Article 7. Execution of sentence imposed abroad. If an offender has undergone execution of sentence imposed abroad because of crime, either in whole or in part, the punishment therefore in Korea may be mitigated or remitted. Article 8. Application of general provisions. The general provisions of this Act shall also apply to such crimes as are provided by other acts and subordinate statutes unless provided otherwise by such acts and subordinate statutes. Chapter 2. Crime. Section 1. Commission of crime and mitigation or exemption of sentence. Article 9. Criminal minors. The act of a person under 14 years of age shall not be punished. Article 10. Persons with mental disorders. 1. The act of a person who, because of mental disorder, is unable to make discriminations or to control one's will, shall not be punished. 2. For the conduct of a person who, because of mental disorder, is deficient in the abilities mentioned in the preceding paragraph, the punishment shall be mitigated. 3. The provisions of the preceding two paragraphs shall not apply to the act of one who, in anticipation of danger of a crime, has intentionally incurred one's mental disorder. Article 11. Deaf mutes. Punishment shall be mitigated for the act of deaf mutes. Article 12. Action compelled. Action compelled by either irresistible force or threat against the life or body of the compelled person or his relatives which cannot be protected shall not be punishable. Article 13. Criminal intent. Act performed through ignorance of the facts which comprise the constituent elements of a crime shall not be punishable, except as otherwise provided by Act. Article 14. Negligence. Act performed through ignorance of the facts which comprise the constituents of a crime by neglect of normal attention, shall be punishable only when prescribed so by Act. Article 15. Misunderstanding of fact. 1. Act performed through ignorance of the facts which constitute especially more severe crimes shall not be punishable for such severe crimes. 2. Crimes for which punishment become more severe due to results thereof, shall not be punishable for more severe crimes if such results were not foreseeable. Article 16. Mistake of fact. When a person commits a crime not knowing that his act constitutes a crime under existing acts and subordinate statutes, he shall not be punishable if the misunderstanding is based on reasonable grounds. Article 17. Causation. Any act which is not connected with the danger which is an element of a crime, it shall not be punishable for the results. Article 18. Crime committed through omission. When a person who, having a duty to prevent the occurrence of danger, or having caused the occurrence of danger, does not prevent the occurrence of danger, that person shall be punished in accordance with the results of such danger. Article 19. Concurrence of independent act. When a series of independent acts concur at the same time or at several times, each act shall be punished as an attempted crime, if it is not ascertainable which act has produced the result thereof. Article 20. Justifiable act. An act which is conducted in accordance with acts and subordinate statutes, or in pursuance of accepted business practices, or other action which does not violate the social rules shall not be punishable. Article 21. Self-defense. 1. An act which is performed in order to prevent impending and unjust infringement of one's own or another person's legal interest shall not be punishable if there are reasonable grounds for that act. 2. When a preventive act has exceeded normal limits, the punishment may be mitigated or remitted according to the extenuating circumstances. 3. In the case of the preceding paragraph, an act performed through fear, surprise, excitement, or confusion in the night or under other extraordinary circumstances shall not be punishable. Article 22. Necessity. 1. An act which is performed in order to avoid impending danger against one's own or another person's legal interest shall not be punishable when there are reasonable grounds. 2. The provisions of the preceding paragraph shall not apply to a person charged with duties not to avoid the danger. 3. The provisions of paragraphs 2 and 3 of the preceding article shall apply mutatis mutandis to this article. Article 23. Self-help. 1. When it is impossible to preserve a claim by legal procedure, the action taken in order to avoid the impossibility or significant difficulties of its execution shall not be punishable when there are reasonable grounds. 2. When the action defined in the preceding paragraph has exceeded reasonable limits, the punishment may be mitigated or remitted according to the circumstances. Article 24. Consent of victim. An act which infringes a legal interest with the consent of one who is authorized to dispose of such interest shall not be punishable except as otherwise provided by acts. Section 2. Criminal attempts. Article 25. Criminal attempts. 1. When an intended crime is not completed or if the intended result does not occur, it shall be punishable as an attempted crime. 2. The punishment for attempted crime may be mitigated than that of consummated crime. Article 26. Voluntarily ceased crime. When a person voluntarily ceases his criminal act which he began or prevents the result of the culmination thereof, the punishments shall be mitigated or remitted. Article 27. Impossible crime. Even though the occurrence of a crime is impossible because of the means adopted for the commission of the crime or because of mistake of objects, the punishment shall be imposed if there has been a resulting danger, but the punishment may be mitigated or remitted. Article 28. Conspiracy and preparation. When a conspiracy or the preparatory action for a crime has not reached commencement stage for the commission of the crime, the person shall not be punishable, except as otherwise provided by acts. Article 29. Punishment of attempts. The punishment for attempted crimes shall be specifically provided in each article concerned. Section 3. Complicity. Article 30. Co-principals. When two or more persons have jointly committed a crime, each of them shall be punished as a principal offender for the crime committed. Article 31. Instigator. 1. For a person who instigates another to commit a crime, the same punishment shall be applied to the instigator as one who actually commits the crime. 2. When a person is instigated and consents to carry out a crime but does not reach the commencement stage for the commission thereof, the punishment for conspiracies or preparations thereof shall apply mutatis mutandis to the instigator and the instigated person. 3. Even though the instigated person does not consent to the commission of a crime, the preceding paragraph shall apply to the instigator. Article 32. Accessories. 1. Those who aid and abet the commission of a crime by another person shall be punished as accessories. 2. The punishment of accessories shall be mitigated to less than that of the principals. Article 33. Complicity and status. To a person who collaborates in the commission of a crime in which person's status is an element, the provisions of the preceding 3 articles shall apply even though that person lacks such status, provided that when the severity of a punishment varies with the accused status, the heavier punishment shall not be imposed on that person who lacks such status. Article 34. Principle through innocent human agent and aggravation of punishment for particular instigation or aiding and abetting. 1. A person who commits a crime by instigating or aiding and abetting another who is not punishable for such conduct, or who is punishable as an offender through negligence, shall be punishable in accordance with the provision for an instigator or accessory. 2. A person who causes the results envisaged in the preceding paragraph by instigating or aiding and abetting another person who is under his control and supervision, shall be punished by increasing 1/2 of the maximum term or maximum amount of penalty provided for the principal in the case of instigating, and with the penalty provided for the principal in the case of aiding and abetting. Section 4. Repeated crime, recidivism. Article 35. Repeated crime. 1. A person who, having been punished with imprisonment without prison labor or more severe punishment within 3 years after the date on which the execution has been completed or remitted, commits such crimes as shall be punished with imprisonment without prison labor or more severe punishment shall be punished as a repeating offender. 2. Punishment for a repeated crime may be aggravated to twice the maximum term of that specified for such crime. Article 36. Discovery of repeated crime after imposition of sentence. When a repeated crime is discovered after the imposition of sentence, the punishment may be determined de novo by adding to the criminal sentence, provided that this shall not apply in case where the execution of the sentence imposed has been completed or remitted. Section 5. Concurrent crimes. Article 37. Concurrent crimes. Several crimes for which judgment has not become final, or a crime for which judgment to punish with an imprisonment without prison labor or a heavier punishment has become final and the crimes committed before the said final judgment shall be regarded as concurrent crimes. Less than amended by Act No. 7077, January 20, 2004. Greater than. Article 38. Concurrent crimes and application of punishment. 1. When concurrent crimes are adjudicated at the same time, punishment shall be imposed in accordance with the following classification. 1. In the event punishment specified for the most severe crime is a death penalty or imprisonment for life or imprisonment without prison labor for life, the punishment provided for the most severe crime shall be imposed. 2. In the event the punishments specified for each crime are of the same kind, other than a death penalty or imprisonment for life or imprisonment without prison labor for life, the maximum term or maximum amount for the most severe crime shall be increased by 1/2 thereof, but shall not exceed the total of the maximum term or maximum amount of the punishments specified for each crime, although minor fine, or confiscation and confiscation may be imposed concurrently, and 3. In the event the punishments specified for each crime are of different kind other than imprisonment for life or imprisonment without prison labor for life, they shall be imposed together. 2. In regard to each subparagraph of the preceding paragraph, imprisonment and imprisonment without prison labor shall be regarded as the same kind of punishments and punishment shall be done with imprisonment. Article 39. Concurrent crimes not adjudicated. Several judgments and concurrent crimes. Execution of punishment and concurrent crimes. 1. In the event there is a crime which has not been adjudicated among the concurrent crimes, a sentence shall be imposed on the said crime taking account of equity with the case where the said crime is adjudicated concurrently with a crime which has been finally adjudicated. In this case, the said punishment may be mitigated or exempted. Less than amended by Act No. 7623, July 29, 2005 greater than. 2. Deleted. Less than by Act No. 7623, July 29, 2005 greater than. 3. When a person who has been sentenced for concurrent crimes receives amnesty or remission of the execution of punishment with respect to any one of the concurrent crimes, punishment for the remaining crimes shall be determined de novo. 4. In the execution of punishment specified in the preceding 3 paragraphs, the period of sentence already served shall be taken into account. Article 40. Compound crimes. When a single act constitutes several crimes, punishment provided for the most severe crime shall be imposed. Chapter 3. Punishment. Section 1. Kinds and severity of punishments. Article 41. Kinds of punishment. Kinds of punishment shall be as follows. 1. Death penalty. 2. Imprisonment. 3. Imprisonment without prison labor. 4. Deprivation of qualifications. 5. Suspension of qualifications. 6. Fine. 7. Detention. 8. Minor fine, and 9. Confiscation. Article 42. Term of imprisonment or imprisonment without prison labor. Imprisonment or imprisonment without prison labor shall be either for life or for a limited term, and the limited term shall be from 1 month to 30 years, provided that it may be extended 50 years in cases of the aggravation of punishment. Less than amended by Act No. 10259, April 15, 2010 greater than. Article 43. Imposition of sentence, deprivation of qualifications and suspension of qualifications. 1. A person who is sentenced to death penalty, imprisonment for life or imprisonment without prison labor for life, shall be deprived of the qualifications prescribed as follows. 1. Qualifications to become public officials. 2. Suffrage and eligibility under Public Act. 3. Qualifications concerning business under Public Act, for which necessary conditions have been prescribed by acts, and 4. Qualifications to become a director, auditor or manager of a juristic person or an inspector or custodian concerning the business of a juristic person. 2. A person who is sentenced to imprisonment for a limited term or imprisonment without prison labor for a limited term shall be under suspension of qualifications as mentioned in subparagraphs 1 through 3 of the preceding paragraph until the execution of punishment is completed or remitted. Article 44. Suspension of qualifications. 1. Suspension of all or part of the qualifications specified in the preceding article shall be for at least 1 year up to 15 years. 2. When both limited imprisonment or limited imprisonment without prison labor and suspension of qualifications have been concurrently imposed, the term of suspension shall be calculated from the day when the execution of imprisonment or imprisonment without prison labor is completed or remitted. Article 45. Fine. A fine shall be 50,000 won or more, provided that in case of a mitigation, it may be less than 50,001. Less than amended by Act No. 5057, December 29, 1995. Greater than. Article 46, Detention. Detention shall be from 1 day to 30 days. Article 47, Minor Fine. A minor fine shall be from 2,000 to 50,001. Less than amended by Act No. 5057, December 29, 1995. Greater than. Article 48, Confiscation and Additional Collection. 1. A thing which is not the property of a person other than the criminal, or which was acquired by a person other than the criminal with the knowledge of its nature after commission of the crime, may be confiscated in whole or in part if it is 1. A thing which has been used or was sought to be used in the commission of a crime. 2. A thing produced by or acquired by means of criminal conduct, and 3. A thing received in exchange for a thing mentioned in the preceding two subparagraphs. 2. When the things mentioned in the preceding paragraph cannot be confiscated, the equivalent price thereof shall be collected. 3. When only a part of a document, books and drawing, special media records, such as electromagnetic records, etc., or valuable security is confessable, that part shall be destroyed. Less than amended by Act No. 5057, December 29, 1995. Greater than. Article 49, Additional Character of Confiscation. Confiscation shall be imposed in addition to other punishment. Even though a judgment of conviction is not rendered against an accused, confiscation may be ordered when the requisites of confiscation are satisfied. Article 50, Severity of Punishments. 1. The severity of punishments shall be in the order stated in Article 41, provided that imprisonment without prison labor for life shall be deemed to be more severe than limited imprisonment. When the length of a fixed term of imprisonment without prison labor exceeds the length of a fixed term of imprisonment, the imprisonment without prison labor shall be deemed to be the more severe. 2. In case of punishments of the same kind, the one having a longer maximum term or larger maximum amount shall be deemed to be more severe, and when the maximum term or amount is equal, the one having the longer minimum term or larger minimum amount shall be deemed to be more severe. 3. Except for the application of the provisions of the preceding two paragraphs, severity shall be determined by the nature and circumstances of the crime. Section 2, Determination of Punishment. Article 51, General Principles for Determination of Punishment. In determining punishment, the following shall be taken into consideration. 1. The age, character and conduct, intelligence and environment of the offender. 2. Offender's relation to the victim. 3. The motive for the commission of the crime, the means and the result, and 4. Circumstances after the commission of the crime. Article 52, Self-denunciation and voluntary confession. 1. When self-denunciation is made to competent authorities who have the responsibility to investigate the crimes, the punishment may be mitigated or remitted. 2. The preceding paragraph shall apply when voluntary confession is made to the victim in respect to crimes which cannot be prosecuted against the victim's will. Article 53, Discretionary mitigation. When there are extenuating circumstances in relation to the commission of a crime, the punishment may be mitigated. Article 54, Optional penalty and discretionary mitigation. Where there are several kinds of punishments prescribed for a single crime, the kinds of the punishment to be imposed shall first be decided and then a mitigation, if any, shall be made. Article 55, Statutory Mitigation. 1. Statutory mitigation shall be as follows. Less than amended by Act No. 10,259, April 15, 2010. Greater than 1. When a death penalty is to be mitigated, it shall be reduced to imprisonment, with or without prison labor, for life or for at least 20 years up to 50 years. 2. When imprisonment for life, with or without prison labor, is to be mitigated, it shall be reduced to imprisonment, with or without prison labor, for at least 10 years up to 50 years. 3. When limited imprisonment or limited imprisonment without prison labor is to be mitigated, it shall be reduced by 1/2 of the term of the punishment. 4. When deprivation of qualifications is to be reduced, suspension of qualifications for at least 7 years shall be imposed. 5. When suspension of qualifications is to be mitigated, it shall be reduced by 1/2 of the term thereof. 6. When a fine is to be mitigated, it shall be reduced by 1/2 of the maximum amount thereof. 7. When detention is to be mitigated, it shall be reduced by 1/2 of the maximum term thereof. 8. When a minor fine is to be mitigated, it shall be reduced by 1/2 of the maximum amount thereof. 2. When there are several grounds for which punishment is to be reduced by acts, it may be repeatedly mitigated. Article 56, Order of Aggravation and Mitigation. When the grounds for which punishment is to be increased or reduced have occurred at the same time, the following order shall apply. 1. Aggravation pursuant to relevant articles of particular provisions. 2. Aggravation pursuant to Article 34, 2. 3. Aggravation for repeated crimes. 4. Statutory mitigation. 5. Aggravation for concurrent crimes, and 6. Discretionary mitigation for extenuating circumstances. Article 57. Inclusion of number of days of confinement before imposition of sentence. 1. The number of days of confinement before imposition of sentence shall be included in whole or in part to the period of limited imprisonment, or limited imprisonment without prison labor, or lockup at workhouse in respect to a fine or minor fine, or detention. Less than in accordance with the decision on unconstitutionality made by the Constitutional Court on June 25, 2009, the effect of, or in part, in this paragraph becomes null and void. Greater than 2. In cases of the preceding paragraph, 1 day of confinement shall be reckoned as 1 day of the term of imprisonment, or imprisonment without prison labor, or lockup at workhouse in respect to a fine or minor fine, or detention. Article 58, Public Announcement of Judgment. 1. When it is recognized as necessary for the interest of an injured party, public announcement of the judgment may be made at the expense of the accused but only at request of the injured party. 2. When a judgment of not guilty or acquittal is rendered, public announcement of the judgment may be ordered. Section 3. Suspension of imposition of sentence. Article 59. Requisites for suspension of impositions of sentence. 1. If, in cases where punishments of imprisonment or imprisonment without prison labor for not more than 1 year, suspension of qualifications, or fines are to be imposed, there are extenuating circumstances in application of the provisions of Article 51 and the accused shows sincere repentance, the imposition of sentence may be suspended, provided that this shall not apply in case of a person who has previously been convicted and received a sentence of suspension of qualifications or more severe punishment. 2. Even when punishments are concurrently imposed, the imposition of sentence may be suspended either in whole or in part. Article 59-2, Probation. 1. In case where a sentence is suspended, if a guidance and assistance is deemed to be necessary to prevent any second offense, a probation order may be ordered. 2. The period of the probation as referred to in paragraph 1 shall be 1 year. This article newly inserted by Act No. 5057, December 29, 1995. Article 60. Effect of suspension of imposition of sentence. After 2 years have elapsed since the suspension of imposition of sentence, that suspension shall be deemed to be acquitted. Article 61. Nullification of suspension of imposition of sentence. 1. The suspended sentence shall be imposed when another judgment of suspension of qualifications or more severe punishment is rendered, or when a prior conviction resulting in suspension of qualifications or more severe punishment is disclosed during the term of the said suspension of sentence. 2. If a person who is subject to the stay of sentence for which the probation is ordered under Article 59-2 violates the probation order to be observed during the probation period, and the degree of such violation is grave, the suspended punishment may be sentenced less than newly inserted by Act No. 5057, December 29, 1995 greater than. Section 4 Suspension of execution of sentence. Article 62. Requisites for suspension of execution of sentence. 1. Where a sentence of imprisonment, with or without prison labor, for up to 3 years is to be imposed and extenuating circumstances exist, taking into account the facts specified in Article 51, the execution of the sentence may be suspended for a period of at least 1 year up to 5 years, provided that this shall not apply where a sentence is imposed for a crime committed during a period of 3 years after a final judgment sentencing imprisonment without prison labor or any heavier punishment was completed, executed, or discharged. Less than amended by Act No. 7623, July 29, 2005 greater than. 2. When punishments are to be imposed concurrently, execution of a part of the punishment may be suspended separately. Article 62-2, Probation, Social Service or Order to Taking Lectures. 1. In the event that the execution of sentence is stayed, probation orders, social service orders or orders to take lectures may be made. 2. The period of the probation as referred to in paragraph 1 shall be the period in which the execution is stayed, provided that the court may determine the probation period within the limit of the period of stay. 3. Order to do any social service or to take lectures shall be executed within the period of suspension of execution of sentence. This article newly inserted by Act No. 5057, December 29, 1995. Article 63. Nullification of suspension of execution of sentence. When a person who was sentenced a suspension of execution of sentence is sentenced to an imprisonment without prison labor or a heavier punishment due to a crime committed deliberately during the period of the suspension, and if the judgment thereof becomes final, the sentence of suspension of execution of sentence shall be nullified. Less than amended by Act No. 7623, July 29, 2005 greater than. Article 64. Revocation of suspension of execution of sentence. 1. If the facts of the proviso of Article 62 are discovered after suspension of execution of punishment is rendered, the suspension of execution of sentence shall be revoked. 2. If a person who is subject to the stay of execution by which the probation, social service or taking lecture is ordered, under Article 62-2, violates the matters to be observed or the order, and the degree of such violation is grave, the sentence of the stay of execution may be revoked. Less than newly inserted by Act No. 5057, December 29, 1995 greater than. Article 65. Effect of suspension of execution of sentence. After a suspension of sentence is rendered, and the term of suspension has fully elapsed without the sentence being nullified or revoked, the sentence shall lose its validity. Section 5 Execution of punishment. Article 66, Death penalty. The death penalty shall be executed by hanging at a prison. Article 67, Imprisonment. Imprisonment shall be executed by the confinement in prison and performance of prescribed work. Article 68. Imprisonment without prison labor and detention. Imprisonment without prison labor and detention shall be executed by confining in prison. Article 69. Fine and minor fine. 1. Fine and minor fine shall be paid within 30 days from the day when the judgment has become final, but when a fine is imposed, confinement in a workhouse may be concurrently ordered until the amount thereof is paid in full. 2. A person who does not pay a fine in full shall be confined in a workhouse and work for a term of at least 1 day nor more than 3 years, or in case of a minor fine, from 1 day to 29 days. Article 70. Lockup at workhouse. When rendering a sentence of fine or minor fine, the court shall simultaneously determine and decree a substitute term of lockup in the event payment of such fine or minor fine is not made in full. Article 71. Deduction of number of days of lockup. When a person has paid only a portion of a fine or minor fine to which he was sentenced, such number of days corresponding to the amount of money paid shall be deducted, in accordance with the ratio of the entire fine or minor fine to the full period set for lockup. Section 6. Parole. Article 72. Requisites for parole. 1. A person under execution of imprisonment or imprisonment without prison labor who has behaved himself well and has shown sincere repentance may be provisionally released by an act of the administrative authorities when 20 years of a life sentence or 1/3 of a limited term of punishment has been served. Less than amended by Act No. 10,259, April 15, 2010 greater than. 2. If a fine or minor fine has been imposed concurrently with the punishment specified in the preceding paragraph, the amount thereof shall be paid in full in order for the parole to be granted. Article 73. Confinement before imposition of sentence and parole. 1. In connection with release on parole, the number of days of confinement before imposition of sentence which is included in the period of sentence shall be counted as a period that has been served. 2. The number of days of confinement before imposition of sentence counted as the period of confinement for fine or minor fine shall be deemed to be the payment of a corresponding amount in cases referred to in paragraph 2 of the preceding article. Article 73-2. Period of parole and probation. 1. The period of parole shall be 10 years for a person sentenced to imprisonment for life or shall be the remaining term for a person sentenced to imprisonment for a limited term but shall not exceed 10 years. 2. Any person released on parole shall be subject to the probation during the period parole, provided that this shall not apply where the administrative agency which grants the parole deems it unnecessary. This article newly inserted by Act No. 5057, December 29, 1995. Article 74. Nullification of parole. When a judgment has become final by sentence of imprisonment without prison labor or more severe punishment during the period of parole, the grant of parole shall lose its effect, provided that this shall not apply in the cases where the sentence results from a negligence crime. Article 75. Revocation of parole. When a person who has been granted a parole violates the parole regulations concerning surveillance, or matters to be observed for the probation, and the extent of such violation is grave, the parole may be revoked. This article newly inserted by Act No. 5057, December 29, 1995. Article 76. Effect of parole. 1. When the period of parole has elapsed without losing its effect or being revoked, after the disposition of parole is made, the execution of sentence shall be considered to have been terminated. less than newly inserted by Act No. 5057, December 29, 1995 greater than 2. In the case of the preceding two articles, the number of days spent during parole shall not be included in the term of punishment. Section 7 Prescription for execution of judgment of guilty. Article 77, Effect of prescription. A person who has been sentenced guilty shall be relieved of the execution thereof by reason of the completion of the period of prescription. Article 78, Period of prescription. A period of prescription is completed when judgment of guilt has not been executed for the following periods after the judgment has become final. 1. 30 years, in the event of death penalty. 2. 20 years, in the event of imprisonment for life or imprisonment without prison labor for life. 3. 15 years, in the event of imprisonment or imprisonment without prison labor for at least 10 years. 4. 10 years, in the event of imprisonment or imprisonment without prison labor for at least 3 years, or in the event of suspension of qualifications for at least 10 years. 5. 5 years, in the event of imprisonment or imprisonment without prison labor for less than 3 years, or in the event of suspension of qualifications for at least 5 years. 6. 3 years, in the event of suspension of qualifications for less than 5 years, fine, confiscation, or collection, and 7. 1 year, in the event of detention or minor fine. Article 79, Suspension of prescription. A period of prescription shall not elapse during the period of suspension or stay of the execution of punishment or parole, or other period within which the execution is suspended. Article 80, Interruption of prescription. The elapse of the period of prescription shall be interrupted by arrest of a person sentenced to a death penalty, imprisonment, imprisonment without prison labor, or detention, and by instituting execution proceedings in the case of fine, minor fine, confiscation, or collection. Section 8 Extinction of punishment. Article 81, Nullification of punishment. If 7 years have elapsed without, a person who had completed the execution of imprisonment or imprisonment without prison labor, or who had received remission of the execution, being sentenced to suspension of qualifications or more severe punishment after compensating the victim for his damages, the invalidation of the judgment may be rendered at the request of the person himself or a public prosecutor. Article 82, Restoration of rights. In case 1/2 of the term of a suspended sentence has elapsed for any person who had been sentenced to suspension of qualifications without being sentenced to a further suspension of qualifications or more severe punishment after compensating the victim for his damages, the recovery of qualification may be granted upon the request of the person himself or a public prosecutor. Chapter IV Term. Article 83, Computation of period of time. Terms fixed by year or month shall be calculated in accordance with the calendar. Article 84, Computation of term of punishment. 1. Term of punishment shall be calculated from the day when the judgment becomes final. 2. The number of days for which confinement is not enforced in case of imprisonment, imprisonment without prison labor, detention or lockup shall not be counted in the term of punishment. Article 85, First day of execution of punishments and period of prescription. The first day of execution of punishments, or of term of prescription shall be reckoned as a full day regardless of the hour. Article 86, Release Day. Release shall be effected on the day of completion of the term of punishment. Part 2, Individual Provisions. Chapter I, Crime concerning insurrection. Article 87, Insurrection. A person who creates a violence for the purpose of usurping the national territory or subverting the Constitution shall be punished according to the following classifications. 1. A ringleader shall be punished by death, imprisonment for life or imprisonment without prison labor for life. 2. A person who participates in a plot, or commands, or engages in other essential activities shall be punished by death, imprisonment for life, imprisonment or imprisonment without prison labor, for at least 5 years. The same shall also apply to a person who has committed acts of killing, wounding, destroying or plundering, and 3. A person who merely responds to the agitation and follows the lead of another or merely joins in the violence shall be punished by imprisonment or imprisonment without prison labor for not more than 5 years. Article 88, Homicide for purpose of insurrection. A person who kills another for the purpose of usurping the national territory, or subverting the Constitution shall be punished by death, imprisonment for life or imprisonment without prison labor for life. Article 89, Attempts. Attempts to commit the crimes specified in the preceding 2 articles shall be punished. Article 90, Preparations, Conspiracies, Agitation, or Propaganda. 1. Anyone who prepares or conspires with intent to commit the crimes of Article 87 or 88 shall be punished by imprisonment, or imprisonment without prison labor for at least 3 years, but when he denounces himself before the intended crime is committed, the punishment shall be mitigated or remitted. 2. The preceding paragraph shall apply to a person who agitates or propagates the crimes specified in Article 87 or 88. Article 91, Definition of subverting Constitution. The purpose of subverting the Constitution in this chapter shall mean those acts which fall within any one of the following subparagraphs. 1. To extinguish the function of the Constitution or acts without observing the procedure provided by the Constitution or acts, and 2. To overthrow government organs established by the Constitution or to render the exercise of their functions impossible by force. Chapter 2, Crimes concerning foreign aggression. Article 92, Inducement of foreign aggression. A person who, in conspiracy with a foreign country, causes to commence hostilities against the Republic of Korea, or who, in conspiracy with foreigners, fight against the Republic of Korea, shall be punished by death or imprisonment for life. Article 93, Taking side with enemy. A person who fights against the Republic of Korea by joining an enemy country shall be punished by death. Article 94, Benefiting enemy by levying soldiers. 1. A person who levies soldiers for an enemy country shall be punished by death or imprisonment for life. 2. A person who applies for conscription referred to in the preceding paragraph shall be punished by imprisonment for life or at least 5 years. Article 95, Benefiting enemy by providing equipment. 1. A person who provides an enemy with country troops, fortresses, camps, or vessels, airplanes, such other places, equipments or structures to be used for military purpose, shall be punished by death or imprisonment for life. 2. A person who provides an enemy with country arms, ammunition, or such other goods to be used for military purpose shall also be punished as prescribed in the preceding paragraph. Article 96. Benefiting enemy by destroying equipment. A person who, for the benefit of an enemy country, destroys or makes preceding article, shall be punished by death or imprisonment for life. Article 97. Benefiting enemy by delivering goods. A person who delivers to an enemy country such arms or ammunition as are not currently used for military purpose or goods usable for battle shall be punished by imprisonment for life or at least 5 years. Article 98. Spy. 1. A person who acts as a spy for an enemy country, or aids or abets a spy of an enemy country, shall be punished by death, imprisonment for life or for at least 7 years. 2. The preceding paragraph shall also apply to a person who divulges military secrets to an enemy country. Article 99. Benefiting enemy by other methods. A person who injures military interests of the Republic of Korea or delivers an enemy country military benefit by crimes other than those specified in the preceding 7 articles, shall be punished by imprisonment for life or at least 3 years. Article 100. Attempts. Attempts of the crimes provided in the preceding 8 articles shall be punished. Article 101. Preparations, conspiracies, agitation or propaganda. 1. A person who prepares or conspires with intent to commit any of the crimes of Articles 92 through 99 shall be sentenced to imprisonment for a limited term of at least 2 years, provided that when he denounces himself before carrying out the commission of the intended crimes, the punishment shall be mitigated or remitted. 2. The preceding paragraph shall apply to a person who agitates or propagates any of the crimes specified in Articles 92 through 99. Article 102. Quasi-enemy country. A foreign country or a group of foreigners in any of the crimes specified in Article 93 through the preceding article takes hostile action against the Republic of Korea shall be deemed an enemy country. Article 103. Non-performance of munition contract in wartime. 1. A person who, without justifiable reason, does not perform a contract concerning munitions or military structures for the government in time of war or during a warlike incident shall be punished by imprisonment for not more than 10 years. 2. A person who obstructs another from performing a contract specified in the preceding paragraph shall also be punished in accordance with the provisions of the preceding paragraph. Article 104. Allied power. The provisions of this chapter shall apply to the act committed against an allied power. Article 104-2 deleted. Less than by Act No. 4040, December 31, 1988 greater than. Chapter 3 Crimes concerning the national flag. Article 105. Profanation of national flag or national emblem. A person who damages, removes or stains the national flag or the national emblem for the purpose of insulting the Republic of Korea shall be punished by imprisonment or imprisonment without prison labor for not more than 5 years, suspension of qualifications for not more than 10 years, or a fine of not more than 7 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. Article 106. Defamation of national flag or national emblem. A person who defames the national flag or the national emblem for the purpose mentioned in the preceding article shall be punished by imprisonment or imprisonment without prison labor for not more than 1 year, suspension of qualification for not more than 5 years, or a fine of not more than 2 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. Chapter IV Crimes concerning foreign relations. Article 107. Assaults, etc. against foreign sovereign. 1. A person who uses violence or intimidation against the sovereign of a foreign country sojourning in the Republic of Korea shall be punished by imprisonment or imprisonment without prison labor for not more than 7 years. 2. A person who insults or defames the sovereign of a foreign country as referred to in the preceding paragraph shall be punished by imprisonment or imprisonment without prison labor for not more than 5 years. Article 108. Assaults, etc. against foreign envoy. 1. A person who uses violence or intimidation against the envoy of a foreign country sent to the Republic of Korea shall be punished by imprisonment or imprisonment without prison labor for not more than 5 years. 2. A person who insults or defames the envoy of a foreign country as referred to in the preceding paragraph shall be punished by imprisonment or imprisonment without prison labor for not more than 3 years. Article 109. Profanation of foreign flag or foreign emblem. A person who, for the purpose of insulting a foreign country, damages, removes or stains a foreign national flag or emblem which is officially used for such country shall be punished by imprisonment or imprisonment without prison labor for not more than 2 years or by a fine not exceeding 3 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. Article 110. Consent of victim. No public action may be instituted against the crimes as prescribed in Articles 107 through 109, against the express objection of the foreign government concerned. Less than amended by Act No. 5057, December 29, 1995 greater than. Article 111. Private war against foreign country. 1. A person who wages a private war against a foreign country shall be punished by limited imprisonment without prison labor for at least 1 year. 2. Attempts to commit crimes specified in the preceding paragraph shall be punished. 3. A person who makes preparations or conspires with intent to commit the crime of paragraph 1 shall be punished by imprisonment without prison labor for not more than 3 years or by a fine not exceeding 5 million won. Provided that when he denounces himself before the commission of such intended crimes, the punishment shall be mitigated or remitted. Less than amended by Act No. 5057, December 29, 1995 greater than. Article 112. Violations of neutrality orders. A person who violates an order concerning neutrality in a war between foreign countries shall be punished by imprisonment without prison labor for not more than 3 years or a fine of not more than 5 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. Article 113. Divulgence of diplomatic secrets. 1. A person who divulges diplomatic secrets shall be punished by imprisonment for not more than 5 years or by a fine not exceeding 10 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. 2. The preceding paragraph shall apply to a person who searches for or collects diplomatic secrets for the purpose of divulging them. Chapter versus Crimes against Public Peace. Article 114. Organization of criminal groups, etc. A person who organizes a syndicate or group with the intent to commit a crime punishable by death or imprisonment for life or for at least 4 years or who joins such syndicate or group or becomes a member of such syndicate or group shall be punished by the penalty prescribed for the intended crime, provided that the penalty may be mitigated. This article wholly amended by Act No. 11731, April 5, 2013. Article 115. Riot. Persons who assemble in large numbers and use violence or intimidation or take destructive action shall be punished by imprisonment or imprisonment without prison labor for at least 1 year up to 10 years or by a fine not exceeding 15 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. Article 116, Failure of dispersion of masses. Persons who assemble in large number for the purpose of using violence or intimidation or taking destructive action and do no disperse after being ordered to do so for 3 or more times by officials authorized to control such matters, shall be punished by imprisonment or imprisonment without prison labor for not more than 2 years or by a fine not exceeding 3 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. Article 117, Non-fulfillment of contract of public demand in wartime. 1. A person who fails to perform, without justifiable reasons, a concluded contract for the supply of food or other necessities of life with the state or a public organization in wartime, calamity or other warlike incident shall be punished by imprisonment for not more than 3 years or by a fine not exceeding 5 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. 2. The preceding paragraph shall apply to a person who interferes with the performance of the contract of the preceding paragraph. 3. In the case of the preceding 2 paragraphs, the prescribed fine may also be concurrently imposed. Article 118, False impersonation of public official. A person who exercises official authority by false impersonation of a public official shall be punished by imprisonment for not more than 3 years or by a fine of not more than 7 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. Chapter V. Crimes concerning explosives. Article 119, Use of explosives. 1. One who injures a person or damages property or disturbs the public peace by using explosives shall be punished by death or imprisonment for life or for at least 7 years. 2. A person who commits the crimes of the preceding paragraph in time of war, calamity, or other warlike incident shall be punished by death or imprisonment for life. 3. Attempts to commit the crimes of the preceding 2 paragraphs shall be punished. Article 120, Preparations, Conspiracies and Instigation. 1. A person who prepares or conspires with intent to commit the crimes of paragraphs 1 and 2 of the preceding article, shall be punished by imprisonment for at least 2 years, but if he denounces himself before the commission of the intended crimes, the punishment shall be mitigated or remitted. 2. The preceding paragraph shall apply to a person who instigates another to commit the crimes of paragraphs 1 and 2 of the preceding article. Article 121, Manufacture, etc. of explosives in wartime. A person who manufactures, imports, exports, delivers or possesses explosives without justifiable reason in time of war or warlike incident, shall be punished by imprisonment for not more than 10 years. Chapter 7 Crimes concerning the duties of public officials. Article 122, Abandonment of duties. A public official who refuses to perform his duties or abandons his duties without justifiable reason shall be punished by imprisonment or imprisonment without prison labor for not more than 1 year or suspension of qualifications for not more than 3 years. Article 123, Abuse of authority. A public official who, by abusing his official authority, causes a person to perform the conduct which is not to be performed by the person, or obstructs the person from exercising a right which the person is entitled to exercise, shall be punished by imprisonment for not more than 5 years and suspension of qualifications for not more than 10 years, or fine not exceeding 10 million won. less than amended by Act No. 5057, December 29, 1995, greater than. Article 124, Unlawful Arrest and Unlawful Confinement. 1. If a person who performs or assists in activities concerning judgment, prosecution, police, or other functions involving the restraint of the human body, arrests or imprisons another by abusing his official authority, he shall be punished by imprisonment for not more than 7 years and suspension of qualifications for not more than 10 years. 2. Attempts to commit the crimes specified in the preceding paragraph shall be punished. Article 125, Violence and Cruel Act. A person who, in performing or assisting in activities concerning judgment, prosecution, police or other functions involving the restraint of the human body, commits an act of violence or cruelty against a criminal suspect or against another person while in the performance of his duties, shall be punished by imprisonment for not more than 5 years and suspension of qualifications for not more than 10 years. Article 126, Publication of Facts of Suspected Crime. A person who, in the performance or supervision of, or in the assistance in, functions involving prosecution, police, or other activities concerning investigation of crimes, makes public, before request for public trial, the facts of a suspected crime which have come to his knowledge during the performance of his duties, shall be punished by imprisonment for not more than 3 years, or suspension of qualifications for not more than 5 years. Article 127, Divulgence of Official Secrets. A public official or former public official who divulges official secrets obtained in the course of performing his duties and classified by acts and subordinate statutes as secret shall be punished by imprisonment or imprisonment without prison labor for not more than 2 years or suspension of qualifications for not more than 5 years. Article 128, Obstruction of Election. A public official, having duties concerning prosecution, police or army, who intimidates a voter, candidate, or a person who seeks to be candidate, in an election provided for by acts and subordinate statutes, or who obstructs the freedom of election by any other means, shall be punished by imprisonment for not more than 10 years and suspension of qualifications for at least 5 years. Article 129, Acceptance of Bribe and Advance Acceptance. 1. A public official or an arbitrator who receives, demands or promises to accept a bribe in connection with his duties, shall be punished by imprisonment for not more than 5 years or suspension of qualifications for not more than 10 years. 2. If a person who is to become a public official or an arbitrator receives, demands or promises to accept a bribe in response to a solicitation, in connection with the duty which he is to perform and he actually becomes a public official or arbitrator, imprisonment for not more than 3 years or suspension of qualifications for not more than 7 years shall be imposed. Article 130, Bribe to third person. A public official or an arbitrator who causes, demands or promises a bribe to be given to a third party on acceptance of an unjust solicitation in connection with his duties shall be punished by imprisonment for not more than 5 years or suspension of qualifications for not more than 10 years. Article 131, Improper Action after Acceptance of Bribe and Subsequent Bribery. 1. If a public official or an arbitrator takes an improper action after committing the offenses under the preceding 2 articles, imprisonment for a limited term of at least 1 year shall be imposed. 2. If a public official or an arbitrator receives, demands or promises to receive a bribe, or causes, demands or promises a bribe to be given to a third party, after taking an improper action in the course of performing his duties, the punishment specified in the preceding paragraph shall be imposed. 3. If a person who was a public official or an arbitrator receives a bribe or demands or agrees to receive a bribe after taking an improper action in the course of performing his duties on acceptance of a solicitation made during his incumbency, imprisonment for not more than 5 years or suspension of qualifications for not more than 10 years shall be imposed. 4. In the case of the preceding 3 paragraphs, suspension of qualifications for not more than 10 years may concurrently be imposed. Article 132. Acceptance of bribe through good offices. A public official who, by taking advantage of his post, receives, demands or agrees to receive a bribe concerning the use of the good offices in connection with the affairs which belong to the functions of another public official, shall be punished by imprisonment for not more than 3 years or suspension of qualifications for not more than 7 years. Article 133. Offer, etc. of bribe. 1. A person who promises, delivers or manifests a will to deliver a bribe as stated in Articles 129 through 132 shall be punished by imprisonment for not more than 5 years or by a fine not exceeding 20 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. 2. The preceding paragraph shall apply to a person who, for the purpose of committing the crime specified in the preceding paragraph, delivers money or goods to a third party, or receives such delivery with the knowledge of its nature. Article 134. Confiscation and subsequent collection. A bribe received or money or goods to be received as a bribe by an offender or by a third party having knowledge of its nature shall be confiscated, or, if confiscation is impossible, the value thereof shall be collected. Article 135. Aggravation of punishment for crimes in course of official duty. A public official who, taking advantage of his official authority, commits a crime other than those specified in this chapter, shall be punished by increasing 1/2 of the penalty specified for the crime committed, provided that this shall not apply in those cases where the punishment for the crime committed is specially prescribed because of the status of the public official. Chapter 8. Crimes concerning obstruction of the performance of official duties. Article 136. Obstruction of performance of official duties. 1. A person who uses violence or intimidation against a public official engaged in the performance of his duties shall be punished by imprisonment for not more than 5 years, or 5 not exceeding 10 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. 2. The preceding paragraph shall apply to a person who uses violence or intimidation against a public official in order to cause him to perform, or refrain from performing an official act or in order to force his resignation. Article 137. Obstruction of performance of official duties by fraudulent means. A person who interferes with the execution of duties by a public official by fraudulent means shall be punished by imprisonment for not more than 5 years, or 5 not exceeding 10 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. Article 138. Contempt of court or National Assembly. A person who insults a court or the National Assembly or creates a disturbance in or near a court or the National Assembly for the purpose of disturbing or threatening the conduct of a court or the discussion of the Assembly, shall be punished by imprisonment for not more than 3 years or by a fine not exceeding 7 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. Article 139. Obstruction of official duties for vindication of human rights. A person who, performing police duties or assisting in such duties, interferes with the execution of duties of a public prosecutor concerning the vindication of human rights or who does not follow his instructions concerning the vindication of human rights, shall be punished by imprisonment for not more than 5 years or suspension of qualifications for not more than 10 years. Article 140. Rendering null and void symbol of official secrecy. 1. A person who damages or conceals a seal or symbol of attachment or other execution which a public official has levied in his official duties or reduces its utility by any other methods, shall be punished by imprisonment for not more than 5 years or by a fine not exceeding 7 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. 2. Any public official who opens any sealed or secretly designed document, book or picture in relation with his duties, shall also be punished by the same punishment as referred to in paragraph 1. Less than amended by Act No. 5057, December 29, 1995 greater than 3. Any public official who detects, book, picture, or special media records, such as electromagnetic records, etc., using any technical means, shall also be punished by the same punishment as referred to in paragraph 1. Less than newly inserted by Act No. 5057, December 29, 1995 greater than. Article 140-2. Infringement on effect of compulsory execution to immovables. Any person who trespasses on any immovables vacated or delivered by any other way, shall be punished by imprisonment for not more than 5 years, or a fine not exceeding 7 million won. This article newly inserted by Act No. 5057, December 29, 1995. Article 141. Invalidity of public documents, etc. and destruction of public goods. 1. A person who damages or conceals documents or other goods, or special media records, such as electromagnetic records, etc., used by a public office or spoils its utility by other methods, shall be punished by imprisonment for not more than 7 years or by a fine not exceeding 10 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. 2. A person who destroys structures, vessels, trains, or airplanes, used by public offices, shall be punished by imprisonment for at least 1 year to 10 years. Article 142. Invalidity of goods kept in public custody. A person who damages or conceals his own goods for which a management order was issued by a public office and which have been placed under the custody of another person by order of the public office, or reduces their utility by other methods, shall be punished by imprisonment for not more than 5 years or by a fine not exceeding 7 million won. Less than amended by Act No. 5057, December 29, 1995 greater than. Article 143. Attempts. Attempts to commit the crimes specified in Articles 140 to the preceding article shall be punished. Article 144. Special obstruction of public duty. 1. A person who commits the crimes specified in Articles 136, 138, and 140 to the preceding article through the threat of collective force or by carrying a dangerous weapon shall be punished by increasing 1/2 of the punishments specified in the relevant articles. 2. A person who commits the crime of paragraph 1, to injure a public official shall be punished by imprisonment for a limited term of at least 3 years. If it results in the death of a public official, the perpetrator shall be punished by imprisonment for life or for a limited term of at least 5 years. Less than amended by Act No. 5057, December 29, 1995 greater than. Chapter X. Crimes of Escape and Harboring Criminals. Article 145. Escape and violation of summoning order. 1. A person who, having been in lawful arrest or custody, escapes, shall be punished by imprisonment for not more than 1 year. 2. The preceding paragraph shall apply to a person, having been temporarily set free from custody due to a calamity, grave incident, or pursuant to the application of a law, violates the summoning order without justifiable reason.